Good afternoon. Thank you, everybody, for coming. I'm speaking to you today from the territory of Treaty 6, and I would also like to acknowledge the Métis people of Alberta, who share a very deep connection with this land. I'm joined today by NDP Justice Critic Irfan Sabir. Certainly, this was an important morning for me, and it was so great to have my family, friends, colleagues, and dedicated staff joining me in the morning. And I'm so grateful for all that they have done for me and for Albertans over all of these years. But there is so much more work to do. So let's get back to what matters to Albertans, namely their jobs, a real place, or a real plan to end the chaos in public health care, and long-term sustainable action to address an affordability crisis not seen in more than 2 generations. In the early hours of this morning, while most Albertans were asleep, Danielle Smith and the UCP cut off debate and imposed their job-killing Sovereignty Act on Albertans. They did this the very same day that chiefs from Treaty 6, 7, and 8 all called for the bill to be abandoned. The same day, both Mikisew Cree First Nation and Onion Lake First Nation wrote to the Premier calling for the bill to be scrapped. The same day, the Indigenous Relations Minister openly admitted the Crown had failed in its legal duty to consult with First Nations. And the same day that former Bank of Canada Governor David Dodge said the Sovereignty Act is a signal to investors that Alberta doesn't know what it's doing. Make no mistake, the Sovereignty Act will kill Alberta jobs. Now, the UCP would have us believe that their amendments have somehow fixed the bill. This is false. Many constitutional scholars in Alberta have reviewed the amendments and found that the bill remains likely unconstitutional. The Act still attempts to give Smith and her cabinet the power to decide what the Constitution says. This function has always been reserved for the courts. Worse than its constitutionality, the Act will leave people and businesses in Alberta subject to 2 different sets of rules about the same thing at the same time. This creates massive uncertainty. Now, yesterday, as I noted, the Indigenous Relations Minister said publicly that the UCP had failed to consult with First Nations. I'm alarmed to think the Indigenous Relations Minister doesn't understand this. But consultation isn't just a polite thing to do. It's a legal duty when the government is bringing in legislation with wide-ranging consequences for treaty rights holders in Alberta. The Sovereignty Act is the UCP trying to overwrite and ignore the Canadian Constitution. This can only possibly create chaos and uncertainty. And it's a terrible signal to investors that they cannot rely on the rule of law or the application of due process if they invest their money in Alberta. Rather, they will be subject to the whims of a premier with a record of extremist views and dishonesty. We cannot afford to let Smith's job-killing Sovereignty Act inject chaos into our province because it will hurt our economy. So today, along with Irfan Sabir, we are calling on Danielle Smith to refer this act immediately to the Alberta Court of Appeal for a ruling on its constitutionality before the act is proclaimed and becomes law. Section 26 of the Judicature Act allows Cabinet to refer any matter to the Court of Appeal for consideration. I believe this act will fail in the courts, but for the sake of Alberta workers, we should get that ruling as quickly as possible to limit the chaos and the uncertainty this act creates solely through its existence. Let's move immediately to settle this huge amount of chaos and uncertainty. I'm deeply concerned about the impact of the Sovereignty Act on the Alberta economy over the next 6 months. There are billions of dollars worth of investment decisions for major industrial projects in Alberta that are pending right now. These are projects that could create good-paying jobs for decades to come if they proceed, and we cannot afford to put them in jeopardy. Alberta lost 15,000 jobs last month. We cannot allow Danielle Smith's job-killing Sovereignty Act to deter investment in Alberta for the next 6 months. So the quickest route to a solution is for this act to go directly to the courts. Thank you, and we're happy to take any questions you might have.
Thanks, and we'll start with questions in person.
Thanks. Well, morning, Rachel. Dean from CP. Sorry, still got a cough. I guess a bit of a two-pronged question. One is, I mean, where are we at now with this bill? I mean, we're now it's passed the ledge, but now it hasn't been proclaimed. So where are we now? And you make an interesting point about the courts. And the problem with this bill is that the bill says that the legislature gets to decide what the Constitution is. So how do you send it to a court to decide whether or not it actually is in charge? I mean, you could then make the argument that the court is actually an interested party, not a disinterested party. I mean, where are we at with how we do this legally?
Well, of course, you know, you raise practical considerations that a lot of folks, just with common sense, would ask. That's partially why this bill stands to upend and undermine the concept of the rule of law in this country and in this province. However, the fact of the matter is that it is still a bill of the provincial legislature, and under the Judicature Act, there is capacity for such a bill to be referred to the Court of Appeal immediately for them to render an opinion on this. This has been called for by the opposition in other occasions in the past where the provincial government is risking overstepping its authority. And so by doing that now, what you do is you send a message to investors, hey, we still remember that the courts exist and the law is a thing here in Alberta. Calm down, don't worry. And you also set out a clear path for finding out the answer. By holding on to it and just pretending that it doesn't exist or not, who knows what they're going to do, it is there. Nothing is in play to bring about the resolution and ultimately the rejection of this bill. And as long as that exists and Danielle Smith is trying to pretend she's a Court of Appeal judge, which is essentially what she's trying to do in this act, the message is sent to investors both outside of Alberta and outside of Canada that Alberta is not the place to choose when you're deciding where to place your investment dollars.
And I wonder if I can get your thoughts on the Premier's comments in her address to the bill, particularly 3 points. One is Ottawa, it's not like Ottawa's a national government, her definition of federalism, and I have to listen to this again, but she accused you of the NDP of colluding with enemies. She said enemies of Alberta. What is that about? And so are you colluding with enemies of Alberta?
You know, let me step back just a little bit. Today we heard an interview with a fellow named Barry Cooper, who was one of the architects of this bill. And in that interview, he very overtly identified his view that this bill is likely not constitutional and that he believes that Alberta moving down the path towards separation is actually something we should be pursuing. The comments made by Danielle Smith last night demonstrate that her view is actually that which is aligned with these fringe separatist wannabes like folks who drafted the Free Alberta strategy. They are dangerous. In essence, at 12:30 last night, when she thought nobody was listening, the veil was lifted. And Danielle Smith's interest in genuinely pursuing initial steps towards separation were revealed. Those comments are utterly chaos-inducing. They are deeply flawed and inaccurate and ill-informed and naive and thoughtless, and they will do damage to the regular day-to-day lives of Alberta and Albertans while she is playing around in an area that she clearly does not understand. So it was very disturbing when I had those comments relayed to me, and particularly in the context of the additional comments that we heard about in other media sources this morning from one of her allies.
Is there any advantage to the government filing the reference case as opposed to it coming to court from, say, Indigenous people who say, you have violated my treaty rights? Is there any difference in how the court case plays out?
I would argue that it probably would be faster if the government were to avail itself of Section 26 of the Judicature Act. Things would move faster, and so I think that would help with the certainty. I have no doubt that there are a range of Albertans who will still challenge this bill, but in my view, the government has a responsibility to act quickly to mitigate the profound level of uncertainty that the act and the wildly contradictory statements from the premier is creating. We heard her say that she's, at the beginning of this act, that this is all about being part of a united Canada and all about making Canada better and all that kind of stuff. And then last night, we heard something profoundly different. And moments after that, the act passed. And so the disparity in terms of the premier's own understanding of what she's just done is in and of itself deeply, deeply concerning.
Okay. A lighter note on another topic, the portrait. I don't know how it works in Alberta, but should you win another term, do you get another painting?
Honestly, I think that'd be a bit unprecedented, so I don't know that I know the answers. But let me just say this. My focus right now is not on any form of post-election accolades. My focus is on Alberta, on Albertans, affordability, healthcare, growing our economy, and making a case to Albertans so I earn the privilege of their vote in the next election.
Hello. The Lieutenant Governor had previously suggested she might seek legal advice before giving royal assent to the Sovereignty Act. Is that something that you would like to see explored?
I think that in some ways that's going to create more chaos, and I don't think that is the best path, but I'm not giving advice to the LG. I would rather see the leaders who have been elected by Albertans on behalf of Albertans to work for Albertans, to engage in a democratically responsible process of honoring our Constitution and finding a way to settle down the chaos that they have created through their unfathomable level of incompetence. And so it's not on the LG. It is on this premier and her cabinet and her caucus.
And reaction to the Deputy Chief Medical Officers of Health resigning?
Well, again, on the theme of chaos, what we are seeing is this premier and her extreme fringe ideas on healthcare drive away incredibly important healthcare leaders and frontline professionals from the work that we as Albertans need them to do. We are in the middle of a public health crisis right now. We have more children in our hospitals seeking ventilation care than we have at any time in the last 3 years. This is a public health crisis. We have a volunteer chief medical officer of health who's continuing to do his whole other job that he's only being paid for that. And now the two deputies who should have been helping our volunteer CMOH are on the verge of leaving and are walking away. And that's chaos. And that's bad for Albertans. And Danielle Smith should be holding a press conference right now, taking as many questions as people want to send to her about what she's going to do to fix the mess she is creating in our healthcare system right now.
We'll go to questions on the phone. Just a reminder to press star 9 if you're joining us on the phone. Use the raise hand function if you're joining us via Zoom. If you could say your name and your outlet at the top, we'll go to our first caller.
Hi, Rachel. It's Michelle Belfontaine from CBC. Couple of things. What do you think about the fact that Ministers Taves, Schultz, Sani, and Jean did not show up last night to even vote the Sovereignty Act? I mean, since they were opposed to it last summer and then got on board, presumably when, once Premier Smith took office and they were offered cabinet posts.
I give them no credit and I read nothing into their presence or absence last night, because the fact of the matter is that they've all been asked in question period and given the opportunity to stand up, show leadership, and speak against this bill in the same way for the same reasons that they identified during their leadership contest. They remained silent. So whether they showed up or didn't show up is irrelevant to me. They own the consequences of this profoundly chaotic initiative as much as the Premier does.
Any follow-up, Michelle?
Yes, please. And on the Court of Appeal issue, and I know you're fully aware that AUPE went to court on the other bill one, the Critical Infrastructure Act, and the appeal court judges ruled that, until the act is actually used, until somebody's actually charged under the act in that instance, that, it's only hypothetical. And I'm wondering if there's a fear that the appeal court judges could even use this bill one and make that argument for this bill one. And where does that leave us?
Well, I stand to be corrected by folks with greater legal knowledge than me, but I would suggest that under Section 26 of the Judicature Act, it is actually constructed with a view to having the government ask those kinds of hypothetical questions, as opposed to the grounds that were used by AUPE to take Bill 1 to the court. So depending on the path you take to get to the court, the scope of deliberation that the court will bring to the matter varies. And that's why we're talking about using Section 26.
We'll go to our next caller.
Hi, it's Audrey Never at Fats of Canada. Rachel, can you just explain for the lay person what this process is of reference to the Alberta Appeal Court? How does it work and what would it do? What would it do?
Basically, it's a piece of legislation that gives the provincial government authority to essentially attract the attention of the Court of Appeal, get itself in line, as it were, to go directly to the Court of Appeal without going through lower courts, to ask the Court of Appeal for its opinion about part of the act. So that is a piece of legislation that governs our courts and it governs our government, and it allows the government to ask the courts for their opinion very transparently. And so that's what it does, and it's different than waiting for a citizen or an organization to work its way through all the different levels of court after something's happened to them. It's actually a process that allows the government to say, sober second thought, maybe we'll just ask the Court of Appeal what they think about this.
Any follow-up, Audrey?
Yes, but don't you think that she won't take that path, since we have heard plenty of constitutionalists say that it potentially could not be constitutional? Why would they change course now at the 11th hour?
Well, I would argue that the fact that they had to bring in time allocation so soon after first introducing the bill probably arose because the chorus of opposition and the people pushing back is growing each and every day. So, roughly a week ago, a little over a week ago, we saw the Premier confidently assert that the piece of legislation did not give them the ability to write legislation behind closed doors at the cabinet table. Subsequently, they heard from a lot of people and they realized that they were wrong about what their 8-page piece of flagship legislation said, and they turned around and they brought in an amendment, which, to be fair, did fix that one issue. Didn't fix the constitutionality issues, but did fix that issue. So my thought here is that every day more and more people come out to identify what we know to be true, which is that this is incredibly chaotic and destabilizing to the economy. And my hope is that as more and more people speak out about that, they will engage in a little bit of responsible leadership. and do the work that would allow them to offer a certain amount of assurances to an otherwise very, very skittish national and international investment community.
And we'll go to our next caller.
Hi there, it's Sean calling from CTV News in Edmonton. I know this is not the most important question in Alberta right now, but the Premier did not attend your portrait unveiling today. I'm just wondering what you thought about that.
Honestly, I don't know. I'm sure she had her reasons. I was pleased that Deputy Premier Nathan Neudorf was there, appreciated his comments, and at this point now I'm much more focused not on historical accolades but on future efforts with respect to the next election and the future, quite frankly, of all Albertans.
Any follow-up?
I hear you, but it's also a matter of decorum and tradition and respect, is it not? Do these things not matter in the legislature anymore?
Again, you'd have to talk to the Premier's schedulers and the Premier herself about that. As I say, I appreciate the kind words that I received from Deputy Premier Neudorf, as well as the very entertaining remarks from the Speaker. And of course, very honored to have Elder Buffalo there, and of course, our Lieutenant Governor.
Do one more pass for questions. Star 9 if you're on the phone. Raise hand function if you're joining us via Zoom. Seeing none, that's all for today. Thank you.
Thank you.
Much for watching, and to learn more, check out albertasfuture.ca.